Welcome to Off the Record, a legal podcast.
Hey everybody, welcome back to an all-new episode of Off the Record with Rhett Burney, an experienced attorney serving families across the upstate South Carolina. I am your host, Mike Leon. For more than 30 years, Rhett has helped clients navigate divorce, custody, estate planning, and probate, and he's seen how the smallest details in an estate plan can either keep families close or tear them apart. I know that firsthand, folks. In today's episode, we're going to talk about how to avoid these family feuds after you're gone, because good estate planning isn't about the money. It's about protecting these relationships. Rhett, it's good to see you as always. Let me ask you on the onset here. I'm sure there's many families that assume that having a will automatically shuts down all these arguments. What kinds of disputes do you normally see after someone passes on?
Yeah, it's always about the money, right, Mike?
Yeah.
That's where our fights are. And I will tell you, I have never seen a fight in criminal court, but I have seen fist fights in probate court when families are fighting amongst families, and they're probably the worst fights. And all of this stuff can be prevented. So let's talk a little bit about that, the steps that we can take in order to prevent these fights to the best of our ability. Because at the end of the day, when someone passes away, they don't have any issues anymore. It's those that you leave behind. And one of the goals of estate planning is to protect the family so that these fights don't occur.
When you start the conversation with these people about the estate planning, how do you help clients think through where there could potentially be the disagreement potholes that could arise before they even become a problem?
Yeah, we usually delve into the family dynamics. And I ask them, it sounds like I'm joking, but it's true. Do you like your family? Do you like your children? What are they like? What are your relationships like? What is your relationship like with your children's spouses? Because that tells us a lot as far as what we may need to do in order to plan their estate properly. We can do a document, do a will, do a power of attorney, all of that. That's no problem. But there may be some things during the discussions that come out that will help us prevent those problems. We also talk about how they want to leave their assets. We tell them to be as specific as possible, because if you just leave your personal property to your two children, what does that look like, right? They divide it equally. How do you equally divide a house full of furniture? Do you get it appraised? Do you say, I get a couch, you get a chair? By the number of items. So specificity is great. Of course, that can be very difficult sometimes, but we also tell clients, make sure that just because you told your son that he was going to get your favorite watch, that we put that in the will, because even though you may think everybody understands what you want, that doesn't mean that at the end of the day, they're going to remember that. So it's great that and we tell them discuss it with their family, tell them what you're thinking about. But if you know that your family dynamics are such that there's going to be a lot of problems, we need to know that up front so we can help head that off before those problems exist.
Right, let's piggyback on the watch example. So how much detail should a will include? Is it things like that? And where do you see people go wrong by not being that specific, like your example?
Yeah, so we'll talk about the watch example. Jewelry, I see women oftentimes say, I won't have my jewelry to go to this daughter, and then they have to go to that daughter. Well, that's great. But the problem you run into is you probably have good jewelry and costume jewelry. And so you're going to want them to fight about who gets what. So I like to set up a way for either a third party to determine how that jewelry in this example will be divided, how it will be split. Or we specifically name each piece. Just don't say the ring, right? If you got 10 rings, that does us no good. We need to specify it so when they're dividing those assets, that jewelry, they know exactly what they're getting. Because even though while that, in this case, we'll say the female is alive, their daughters are getting along, as soon as someone passes away, that can change very, very quickly. And I've seen people fight over the worst things, the little things, $500. It's ridiculous, but it happens. And it gets really nasty, really nasty.
So, Rhett, let me ask you, because I mentioned in the intro probate part of this, you've helped families through probate. But from your perspective, what could have been done during the planning process to make things smooth later on?
I always believe communication is the key to everything. So, Lots of times people want to surprise their family in the will, but you may find out that that's going to be, it will be a surprise, but won't get the intended reaction that the person wanted. So I tell them, say, have you talked about what you're wanting to have happen with your family? Hopefully they do have that type of relationship with their family members to where they can talk about it. Because the situation with their property that they're trying to divide may be a situation where you have two pieces of real estate. You were going to leave one to your daughter and one to your son. They may not want that real estate. They may want to switch it. It's good to have those discussions. Plus, once you start talking about it, you can oftentimes start finding out where the issues are going to be. So we can go ahead and figure out a solution to them before something happens to where it's too late.
Rhett, you mentioned before about the communication. So you usually, I'm assuming, recommend families just discuss these estate plans together, right? It's better rather than keeping it private. And how do you handle the awkwardness of broaching those conversations?
Yeah, I mean, we're all adults, right? If your goal really is to preserve your family after your death, then why is it not important to go ahead and have those difficult conversations? I mean, let's face it, you're a parent. You've had or will have those difficult conversations with your children about other things. Why not talk about those things that are definitely going to happen? You're definitely going to die. Let's go ahead and put that out on the table because it may be a relief to your children as well, or to your other loved ones, just to go ahead and talk about it because we're living longer, right? The quality of life after we get older seems to be getting really bad for whatever reason. So it's good to go ahead and let your wishes be known now, but also make sure that when you verbalize those wishes, you put it in writing as well. Because if you tell somebody something and then you do something the exact opposite in, we'll say, your will or your trust, that's going to cause hard feelings. And I can't tell you how many times that has happened where child A will think they're getting a particular asset only to find out later that that was given to child B. So that causes hard feelings. People start this conspiracy theories. You did that to mom, you forced dad to do that. So go ahead and have the conversation, put it out on the table. Hey, the worst thing that someone can say is, I don't agree with you. Who cares? It's your stuff. You can do whatever you want to with it. At least you've had that conversation.
Speaking of hard feelings, I'm sure choosing an executor or trustee can make or create some tension among siblings. What qualities make someone a good choice for that responsibility?
So I ask my clients, which child do they dislike the most? And name that person because it's a lot of work to be the trustee or the personal representative in certain situations. But truthfully, pick the one that has level-headed, even-keeled, common sense. If they can't balance a checkbook, then they probably don't need to be the one who's in charge of your estate assets. If they have a criminal history or lots of judgments against them, they're probably not the most responsible person to be in charge of your assets. If no one gets along with that particular person, don't name them the personal representative or the trustee. If they live halfway around the world, if you have no other choice, or if you have choices, name someone who lives closer because logistically there may be some problems there. So I think you look at the type of person that they are. If you don't trust them with your assets today, are you really going to trust them with your assets when you're not there to watch over them?
Yeah. Rhett, in your years of history here doing all of this, can you share an anonymous example, of course, where good planning prevented that family dispute before it even started?
Yeah. So one thing we've been asked to do is read the will, right? And as lawyers, we laugh because that's really TV stuff. We don't really sit around and read the will, but we have had those situations. And it's interesting when we do it, the people will come into the room and you can tell they're highly agitated and there are a lot of hard feelings for whatever reason, because they've made a lot of assumptions. But when we're able to sit down and read that document, and it is clear, especially if people, when they're writing their wills or their trust, give reasons why they've done something that they thought would be kind of controversial, that helps lower the tensions. It helps send the message that now that dad has moved on, that he wants the family to continue in a peaceful manner. In my particular will, I left things to certain people for certain reasons, and I spelled that out so that when I'm no longer here, they know why I did what I did, so that there's no questions that have to be answered where people start making the wrong assumptions about my intentions. So, yeah, I've had those situations where because someone took the time to be very clear in what they wanted to have done with their estate, that it prevented a lot of problems moving forward.
Red, as we wrap here on this episode, they always say you should revisit these every 3, maybe 5 years. So if someone's unsure right now, they're listening to this episode, they're unsure if their will or their trust is going to cause some tension later. What's one sign that it might be time to revisit that plan?
Yeah, look at the current relationship. Is the relationship as good now as it was back when you wrote this document? Has someone gotten remarried? Has someone died? Have you had children or grandchildren born during that time? What's your health like? What's the health like of those individuals that you've named to be in charge of your estate or that you're giving some assets to? So look at the situation. It's changing all the time. That's why we say you should review it every 3 to 5 years, or if there's some type of life-changing event. So that's why we want people to do it. And so when you are doing it, look around and say, hey, the situation is not as good as it used to be, or it's better. What do we need to change in order to make sure that we're not having problems in the future?
Brett, thanks for the time and insights analysis. We appreciate it as always.
Great, Mike. Thank you.
And thank you to everyone out there for listening to this installment of Off the Record with Rhett Burney over at Rhett Burney Law in Simpsonville, South Carolina. If you want to learn more about wills, trust, family focus, estate planning, do me a favor, visit rhettburney.com today. Don't forget to subscribe, like, leave a review and comment, or share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.